The most popular ways to shift risk in a contract are indemnity obligations, which we've talked briefly about, additional insurance clauses, right, which would be an agreement that one party will make the other party an additional insured and covered by the insurance, by their own insurance. You can have limitations on liability that will prevent a party with whom you have a contract from making certain kind of claims. For example, it's very popular in contracts where people are selling goods that they will limit the warranties they provide on those goods, or they will limit their exposure to the cost of the goods that were purchased, so that if something terrible goes wrong, they'll only have to pay back the money they've already made. Another popular manner of shifting risk or avoiding risk in a contract is to exclude consequential damages. And consequential damages would be the damages that sort of come after whatever the loss is that you've been asked to repair. Additional insurance is very tricky. Additional insurance, like everything else that we sign, or every other business agreement we enter into, additional insurance is defined by the insurance policy. If the insurance policy has an endorsement that reflects back to the contract, you have to look back at the contract to determine exactly what the endorsement means. But if you do not understand or read the endorsements, you will not know what your insurance is. One very common exclusion, exception, or limitation that you find in additional insured endorsements is that the additional insured endorsement will only apply if it arises out of the work of the named insured. It may have limitations on the amount that it will cover. It's possible that the additional insurance clause will try to say that it is excess over any other valid collectible insurance. If you don't read the endorsement or you don't read the clause, you won't know if it's effective or not. And another kind of contractual risk shifting is contractual contribution, or the idea that you can agree in a contract that if one of the parties in the contract suffers a liability, then the parties will agree to pay their fair share of the liability. And you can structure that by agreeing that the determination of who has a percentage of fault can be made by an arbitrator. If you're both parties in a lawsuit, you can have a jury make a determination of who has a proportionate responsibility. You could choose to have an umpire, hire a third party who's knowledgeable on these matters to determine who has what kind of liability. It's not indemnity because you're not paying more than your fair share, and you're not paying for someone else's liability, you're paying for your own. But it is an agreement that in cases where there are no indemnity agreements, in cases where you can't have an additional insured agreement, it is a way of shifting risk. Now, you don't know exactly how it's going to turn out, because if you did cause it, you created the problem, and it is your fault. You may be agreeing to pay the entirety of a judgment that's found against somebody else. But for many folks, because it deals with their actions, they feel they can control it, and it is a fair way to split up potential liability in the event that either an indemnity, additional insurance obligation is somehow unenforceable, or if they simply want to have the peace of mind that if they do their work, they do it properly, they're not going to be responsible for losses associated.